Fundamental rights. Very important provision of the Indian Constitution. Fundamental rights are the rights, those are fundamental in nature. Fundamental in nature. That means without these rights, the individual cannot enjoy his life. For making the individual life beautiful, these rights are essential. That's why they are the basic, they are the fundamental in nature. So you know very well, the fundamental rights are taken from USA Constitution, United States of America. In the United States of America, the fundamental rights are called as Bill of Rights. Bill of Rights. We are inspired the American model of Bill of Rights and incorporated fundamental rights in the Part 3 of Indian Constitution. Part 3. Part 3 of Indian Constitution from Article 12 to 35. 12 to 35. Originally, there are 7 fundamental rights. Original Constitution having how many fundamental rights? 7 fundamental rights. Whereas later on one was deleted. Now they became 6 fundamental rights. The deleted one is that right to property. Right to property, which is undercomes Article 31. Article 31, which is deleted from the list of fundamental rights, not by from the Constitution of India. Keep in mind, the right to property, fundamental right deleted from the list of fundamental rights, not deleted from the Constitution of India, because this was deleted from the list of fundamental rights by the 44th Constitutional Amendment Act in the year 1978 and incorporated in the Part 12th of the Indian Constitution, 12th part, under Article 300A as legal right. As legal right. This is very, very important point. You have to note it down. Originally, the fundamental rights are 7 in number. In the year 1978, by the 44 Constitutional Amendment Act, one fundamental right, that is right to property, Article 31, deleted from the list of fundamental rights and incorporated in the Part 12 under 300A article, 300A article as legal right. As legal right. Keep in mind. Then what are the remaining 6 fundamental rights? You know very well. The first fundamental right is that right to equality. Right to equality, which is undercomes Article 14 to 18. Article 14 to 18. And the second right is that right to freedom, which is Article 19 to 22. And third one is that right against exploitation. Right against exploitation. Article 23 and 24. 23 and 24. And fourth one is that right to religion. Right to religion. Under Article 25 to 28. 25 to 28. And fifth one is that cultural and educational rights. Cultural and educational rights. Under which article? Article 29 and 30. Article 29 and 30. 31 article was deleted, that is right to property. Then finally, very important article is that right to constitutional remedies. Right to constitutional remedies. Under Article 32. These are the 6 fundamental rights which are existed at present in the Part 3 of Indian Constitution. What are they? Right to equality, right to freedom, right against exploitation, right to religion, cultural and educational rights, and then finally right to constitutional remedies. So you have to mention in the clear form, in the same order you have to mention while you are discussing about, while you are making the answers, you have to mention the same order. This is the order. Right to equality started with article 14, 18. So by this fundamental rights, the people enjoyed the rights against the legislature, against the executive. That means here the people enjoyed the freedom against the legislative activities, against the executive activity. For a while making the laws against the fundamental rights, we approached to the Supreme Court under Article 32. At the time, Supreme Court imposed some writ petitions. Understood? If any violation of our fundamental right, we have the right to approach. We have to approach to the Constitution of India, Article 32. Article 32, at the time the Supreme Court proclaimed or imposed some writ petitions such as the habeas corpus, mandamus, certiorari, quo warranto. These are the 5 writs we will discuss later on in the fundamental rights chapter. Understand? That's why the fundamental rights are justiciable in nature. Fundamental rights are justiciable in nature. Because while fundamental rights are violated by any legislative activity or executive activity, the judiciary can protect our fundamental rights. That's why they are justiciable in nature. This is also one of the important salient feature of Indian Constitution. We inspired the Bill of Rights and also we inspired the 1948 Universal Declaration of Human Rights by United Nations General Assembly. We also inspired from that. Whereas we incorporated this much of clarity of fundamental rights in part 3 of Indian Constitution. We never seen this type of classification in other constitutions. That is the peculiarity of Indian Constitution. Clear? Then the next one is that directive principles of state policy. Directive principles of state policy also considered as one of the salient features. At the time of making of the Constitution, the Constituent Assembly formulated one advisory committee under the leadership of Vallabhbhai Patel. This committee was again divided into subcommittees. That subcommittee chaired by J.B. Kripalani regarding to the fundamental rights. That committee classified rights are 2 types. One is justiciable, another one is unjusticiable or non-justiciable. The fundamental rights are justiciable, whereas the directive principles of state policy, directive principles of state policy, DPSP, directive principles of state policy are non-justiciable, non-justiciable. Understood? Directive principles of state policy are non-justiciable. They are also rights. Here the rights to whom, they are the directions. Listen, keep it in mind. Directive principles of state policy are the directions given by the Constitution to the state of India for making policies. For making policies. Directive principles. To whom? State. For what? For making policies. That is the definition, that is the meaning of directive principles of state policy. Here, the Constitution of India gave some guidelines to formulate policies, nothing but the welfare policies to the government of India, state of India. So they undercome directive principles of state policy. We have been taken from Ireland Constitution. Directive principles of state policy taken from Ireland Constitution and incorporated in part 4 of Indian Constitution from article 36 to 51. Keep in mind, directive principles of the state policy have been taken from Ireland Constitution or Irish Constitution, incorporated in our Constitution in the Part 4 from Article 36 to 51. Article 36 to 51, there are some directive principles. They are the directives to the Government of India for making welfare schemes, welfare policies. These directive principles are classified into three different forms. Directive principles are classified into three categories. One is socialistic principles. Socialistic principles. Another one is Gandhian principle. And third one is the liberal principles. Liberal and intellectuals. Intellectual, liberal and intellectual principle. So they are the three categories under directive principles of state policy. So here by the socialistic principles, the principles regarding to the convert India into a socialist country. India into a socialistic country. For example, distribution of wealth, elimination of inequalities, understand, and providing the equal pay for equal work, and providing the work to the citizens of India, and also promote the health, and also provide the nutrition. Under comes socialistic principles. That means according to the directive principles under socialistic principles, the Constitution of India gave some guidelines, says India how converted as socialistic country. If the India provide these following directive principles, India became socialistic country. These are the directives which are given by the Constitution to the Government of India, State of India. And Gandhian principles, when you observe the Gandhian principles, they are inspired by the Gandhian ideology. One is implementation of Panchayat Raj, and also promotion of the cottage industries, providing the education, particularly the weaker sections. Like this, the Gandhian principles also undercomes directive principles of state policy. They are inspired by the Gandhian ideology. Liberal and intellectual principles, they also undercomes. For example, if you take example regarding to the environment and regarding to the extending our help to the United Nations organization, and also separation of the judiciary from the executive, they undercomes liberal intellectual principles. Here, the directive principles of state policy also considered as one salient feature of Indian Constitution, which are inspired by the Ireland Constitution. In Ireland, they are called as social principles of state policy. That's why these are the directive principles of the state policy. They are classified into three categories: socialistic principles, Gandhian principles, liberal and intellectual principles. Here, according to the Ambedkar, directive principles of state policy are novel practice, novel features. Who said directive principles as novel features? Novel features means they are the innovative, new features which are never seen in other constitutions. This was given by whom? Dr. B.R. Ambedkar. Ambedkar said that directive principles of the state policy as novel features, new features, innovative features. At the same time, the Constitution of India specially mentioned about the directive principles. They are the very important principles which are must implemented by the government, because if the government is neglected, the India unable to considered as welfare state. And moreover, in the Minerva Mills case 1980, the Supreme Court described both the fundamental rights and directive principles are treated equal weightage. There is a equal weightage because fundamental rights are justiciable in nature, directive principles are non-justiciable in nature. Because here, if the government is not implemented the directive principles, we are unable to approach to the judiciary because they are non-justiciable in nature. Whereas in Minerva Mills case 1980, the Supreme Court of India described both the fundamental rights and the directive principles of state policy are treated equal weightage. So this is about the salient feature of directive principles of state policy. Then the next one is that fundamental duties. Fundamental duties. You know very well. Is there fundamental duties in original constitution? No. In original constitution, there is no fundamental duties. Later on we incorporated. Keep it in mind, all of you. Fundamental duties. Fundamental duties are not existed in original constitution. They are not existed in original constitution because this was the feature which are added later on. When we added to the Constitution of India in the year 1946, that means at the time of 1946, what happened in India? There was an internal emergency. The year 1945, Indira Gandhi government proclaimed internal emergency. At the time of internal emergency, the Indira Gandhi government appoint one committee, that was Swaran Singh committee. Which committee? Swaran Singh committee. Swaran Singh committee appointed by the Indira Gandhi government. This Swaran Singh committee recommended some of the fundamental rights to incorporate in the Indian Constitution. That's why based on the Swaran Singh committee recommendations, we incorporated 10 fundamental duties. 10 fundamental duties by the 42nd Constitutional Amendment Act. Understood? Originally, there are no fundamental rights in our constitution, fundamental duties in our constitution. Whereas in the year 1946, we incorporated 10 fundamental duties to the Constitution of India on the recommendation of Swaran Singh committee, which is appointed by the Indira Gandhi government. So this Swaran Singh committee recommended 10 fundamental duties. They are incorporated in the part 4A. Part 4A and Article 51A. What is the location of the fundamental duties? Part 4A of Indian Constitution and Article 51A. It consists 10 fundamental duties. So that's why keep it in mind, all of you. Originally there are no fundamental duties. Later on we added 10 fundamental duties. Again we added one more fundamental duty to the part 4A of Indian Constitution by the Constitutional Amendment Act 86. Constitutional Amendment Act. In the year 2002, we added one fundamental duty to the part 4A of the Indian Constitution. Now, how many fundamental duties are there? 11 fundamental duties are there. At present, there are 11 fundamental duties in part 4A of the Indian Constitution and Article 51A. So why we are incorporated fundamental duties here? Actually, in original constitution, our constitutional makers did not expect the special mention of the fundamental duties because they thought Indians are responsible people. Whereas they aware later on, Indians are not such a kind of responsible people. They must remembered by the government of India, by the Constitution of India regarding to their duties. Because here, rights given to whom? People. Rights are given to the people by Constitution. That means state. For that, we should give some of the duties to the state. State gave some rights to the citizens. For that, we should give some responsibilities to the state. Toward the state, we should respect, we should give some responsibilities. Duty is nothing but responsibility. That's why we inspired from the Russia, from Russian constitution, nothing but USSR. Previously it was called as USSR constitution. Now it was called as Russian constitution. From the Russian constitution, we have been taken fundamental duties and incorporated in the part 4A of the Indian constitution under article 51A. So the state which expected some responsibilities from the citizen of India. What are the responsibility? Respect our constitution, respect our nation, respect our national flag, and also promote the sovereignty and also integrity, promote the unity and integrity among the people, respect the women. Like this, there are some fundamental duties in our Constitution of India, which are taken from which constitution? Russian one, and also which suggested by Swaran Singh Committee. So these are the fundamental duties. We will discuss very clear in fundamental duties topic. Then the next one is that bicameralism. Bicameralism. You know very well. Already we studied the first year. Bicameralism. The 9th provision is that bicameralism. What is meant by bicameralism? Bicameralism means the legislature which consists two houses, upper house, lower house. Upper house, lower house. The legislature which contains two houses, upper house, lower house. Here upper house, for example, if we take Indian legislature considered as Parliament of India. Parliament of India. In the Parliament of India, there was a bicameral system. Two houses are there, upper house, lower house. In Parliament, upper house is called as Rajya Sabha. Rajya Sabha. Lower house is called as Lok Sabha. Understood? In our Indian parliamentary system, we adapted bicameral system, which inspired by the British model, at the same time USA model. You know very well, the bicameral system which is taken from Britain model, at the same time USA model. Whereas for the first time in India, the bicameral system introduced by 1919 Government of India Act. By the Government of India Act 1919, we introduced bicameral system in India for the first time at which level? Union level, central level. Whereas this was extended to the states. The bicameral system extended to the state by the 1935 Act to the provincial level. Provincial level also. That means there was a bicameral system at union level as well as provincial level, state level in India. But the Constitution of India gave relaxation to the states. That means gave the choice to adapt the bicameral system to the states. If the states are interested, they may adapt bicameral system. Otherwise, they may continue as unicameralism. So keep in mind, in the bicameral system, the legislature which contains upper house, lower house. In Indian point of view, upper house is nothing but the Rajya Sabha, which is representing to the states, and the members of the Rajya Sabha comes from states only. It was not represented to the people. It represented to the states. Whereas the Lok Sabha, which is lower house, here keep in mind, lower house, Lok Sabha. It's easy to remember. This represents directly to the people. It is the people's house. It was Rajya Sabha called as Council of States. Lok Sabha called as House of People. People's house. House of people. Because Lok Sabha represents to the people directly. The members of the Lok Sabha comes from the people directly. That's why we adapted bicameral system in the union level. Whereas at the state level, the constitution gave the choice to the states regarding to the adoption of bicameral system. When you observe the present scenario, India consists 28 states after the Jammu Kashmir incorporation. There are 28 states at the same time 8 union territories. Here, out of the 28 states, how many states are having bicameral system? You have to remember there are 6 states. There are 6 states are enjoyed bicameral system. They followed bicameral system. Out of the 28 states, 6 states are followed bicameral system.